Thank you for joining today's webinar, Breaking J&J ERISA Employee Benefit Lawsuit. Am I at risk? Let's get started.
All right. Hello, everyone. Thank you for joining us for today's webinar regarding the J&J ERISA Employee Benefit Lawsuit. Am I at risk? Today's panelists are Jonathan Levitt and Pramod John. Jonathan Levitt co-founded the national boutique healthcare law firm of Frier Levitt in 2000, beginning with a 2003 national class action of pharmacies against PBMs. Jonathan began the journey to understand all aspects of the drug supply chain. Jonathan was recently invited to testify before the U.S. Senate Committee on Finance during its hearing titled Pharmacy Benefit Managers and the Prescription Drug Supply Chain Impact on Patients and Taxpayers. As a leading voice in the healthcare industry, Jonathan shared his valuable insights into the role of PBMs in the prescription drug supply chain. During his testimony, he addressed many challenges faced by patients in accessing affordable medications, including concerns about the PBM rebate system, the need for greater transparency in PBM practices, repercussions on patients, taxpayers, and independent pharmacies. Jonathan is admitted to practice in multiple states and is certified by the Supreme Court of New Jersey as a civil trial attorney. Thanks, Jonathan, for joining us.
Thank you.
And Pramod John, CEO and team leader at Vivio, a public benefit corporation that is using analytics to reinvent the use and supply chain for specialty drugs. Vivio's solution challenges the current framework of efficacy by extending it to actual effectiveness in the real world, resulting in significant acquisition savings and better outcomes for patients. Vivio's customers have seen reductions in drug spend of over 40% or removing obstacles to care such as formularies. Vivio is growing rapidly, and customers include Fortune 500 organizations in various industries. Pramod also founded Oration, which allowed the capture of prescriptions in physicians' offices and then provided real-time pricing options and automatic routing capabilities. He was also VP of Strategy and Innovation at McKesson, where he helped optimize healthcare delivery systems, and he's a PhD in electrical engineering from the University of Illinois. So thanks, everybody, for joining us. This is obviously a hot topic, something a lot of folks are talking about. So I thought where we'd start, Jonathan, and so there's been lawsuits out there, a lot of people talking about it. Does this have merit from a legal perspective?
So I don't represent the plaintiffs, which is a class of employees at J&J, and I don't represent J&J. And I've just read this complaint, and I've been studying this industry, obviously, for many years, like you gentlemen. And so I think the question is not whether it has merit, but how it's going to impact the industry. And I do think that it will have a dramatic impact on the industry. Some things we're going to talk about next hour are the fiduciary duty, kind of what that means. And I think there's going to be a rethinking of benefits administrators on, wait a minute, how do I be prudent under the law? So I think this is really going to change that narrative. And it truly is the first of its kind type of lawsuit. Plaintiff is a class of employees against an employer saying, you have a duty to me as an employee to manage the pharmacy benefit design, to look at the cost of drugs and rebates and MAC pricing and generic and specialty, and you failed in that way, and you cost me money, and I could have gotten a bigger raise. I would have had lower share in when I paid for my health insurance, even if it's self-funded plan. So I think it's not so important if it has merit, as it is important of like, how is this going to potentially change the industry and decisions made in the industry?
So, Jonathan, is that, because I think that's a key point on fiduciary when you talked about the premiums that people pay, right? Because if we go back and lawsuits, I believe in the 401k industry, and use this fiduciary, the same sort of argument that drastically changed that industry forever. Is that correct?
Absolutely. This is the same blanket ERISA laws. One has to do with, your pension plan. One has to do with your medical and pharmacy benefits. And the same sets of laws.
And
same standards of care.
Got it. And so anything when you're reading through I see we have this up here, failure to exercise prudence. Anything in particular I'm here that if I'm an employer listening in that I'd want to be zeroing in on in this language from the lawsuit?
Yes. And this one single paragraph really requires that benefits design folks ask a bunch of questions. So to take a step back, there is this fiduciary duty on the plan and trustees of the plan to manage the assets having a special duty to the employees. And that duty includes two components: loyalty and prudence. And this one paragraph, this seventh paragraph in, like an 80-page complaint, it says, here's what you didn't do right. Let's start with selecting a PBM. You didn't do a good job when you selected a PBM. And I mean, I know, Pramod, I'm sure you could spend an hour talking about the RFP process and all that's wrong in that process. And this complaint doesn't even go there. But they said, you have control of our plan assets. You're supposed to look at those assets and say, I want to spend money with prudence, with an intelligent idea of what to do. And you unreasonably spent money on specialty drugs. You allowed the PBM to enrich itself. You didn't really look at formulary design. You didn't oversee key aspects of the plan. You failed to rein in PBMs and you just let them make money. So you breached that duty of prudence to us.
Hey, Jonathan, on a related note, I don't know if you saw, but 2 weeks ago, there was the earnings announcement from one of the big three PBMs. And in it, what was fascinating was that this big three PBM had lost one of the largest contracts in history. And you probably all know who that is. But if you looked at how that affected their financials, it didn't affect it as much as one would have thought. And they had listed in their earnings report that one of the reasons for tailwinds for them was, in fact, specialty generic drugs.
Yeah, yeah. And this paragraph, so specialty generic drugs, Pramod. If I am a trustee, or and the trustee is the one who owes a fiduciary duty, or if I'm an employee at a big self-funded plan, and I know I owe a duty of loyalty to all the employees to safekeep the dollar spent in that pharmacy plan. One of the first things I'm looking at is how the PBM has denominated or named certain specialty drugs. So if there's a lot of generics that are called specialty drugs, just so the PBM can make a bigger spread, that in a year from now or 2 years from now, for sure, that's going to be something carefully looked at. That will be considered possibly a breach of fiduciary in the future if you don't understand, if the people in charge of the plan don't really look at those definitions and take a hard look at spread pricing.
It's interesting, Jonathan, you say that, because I think we have a slide here as well that kind of gets into the specifics. It was really on the specialty drug, program of what you're mentioning. And what's interesting about that is there's been some news recently in the PBM industry with Blue Shield of California, disintegrating their PBM relationship. Tyson Foods, public news, disintegrating the PBM relationship. But when you read further, they didn't change specialty. It was still a big three PBM still managing specialty in both of those cases. So can you speak a little bit about the breach that's specifically called out in here? Because it kind of went from PBM to then a more focused within PBM, which was really on the specialty drug program.
So I think, PBMs, look, they owe a duty to shareholders. They owe a duty to make more money. Now, you guys are a public benefits corporation, so you actually don't have that duty. We just need to make money. We need to actually serve a public purpose. That's one thing interesting about the your company, Vivio. But Cigna, owns Express Scripts. They have a duty to shareholders to deliver value. And so how do they do it? They come up with these creative ways. So there's a formulary, a list of drugs. And if you look at and the way the PBM charges self-funded plans, it depends on for each drug. It depends on how the drug is defined. And so there's clearly some drugs that are specialty drugs, and the PBMs make more money on those drugs because they're reimbursed at, let's say, AWP minus 12 as opposed to AWP minus 87%. And so an amazing way to just boost profits is to take a generic drug that's a copy of a specialty drug and just make it a specialty drug, even though it should be $1 a pill, and you make it $3 a pill. Obviously, much larger sums of money at issue, but just to illustrate the point. And so the formularies have migrated these generic drugs into the specialty drug so the PBM can make more money, and the PBMs often own their own pharmacies. All the big PBMs do. And these PBM specialty pharmacies have grown tremendously. And some plans make a decision, whether it's prudent or not, to allow the PBM specialty pharmacy to have exclusive right to do all specialty drugs. And so the PBM is allowing its own, is convincing the plan to allow the PBM to earn huge spread pricing dollars on those specialty drugs, even though they're just generics and they should be way cheaper.
Yeah, and I know we're going to get into some specific things that were called out, in the suit of what I'll have next. But I think it's a really interesting concept, which is just as a fiduciary, what that role is in selecting and negotiating, with the PBM. Yes. And I think there was some specific language in there. If you go to the next slide, that really talks, about that too. And I think there's this broader question that's probably in a lot of people's minds, which is, this is a big three PBM, right? That has 70% plus of the market share, depending on, where you look to believe. So clearly, if you've selected that, which would have been considered the safe choice,
yeah,
right? It's not like that everybody would be exposed to this or have merit if they're in the situation. So do you want to talk about kind of the specific language and why they used it in this way?
Yeah, so this paragraph I pulled out because I just found that it really promotes a discussion like we should be having and your audience members should be having. So here, what they're saying is they're posing a question. That's what I look at this. It says, what do prudent fiduciaries do? So again, fiduciary duty has loyalty and prudence. And prudence means you're exercising the care that a reasonable man should do, reasonable man or woman. So here they're saying you didn't exercise your duty of prudence when you looked at the PBM contract. And our law firm, we look at these contracts and we talk to benefit design people within big self-funded plans. And these contracts are often one-sided in favor of the PBMs. And so negotiating the PBM contract and not allowing PBM to, say whatever they want is a problem. And that's one of the things that they go into here. They also say here, they talk about rebates. We interview, it's confidential attorney-client privilege discussions, but we interview plans and we ask them, did you audit your PBM and the rebate aggregator for rebates? And, we get answers that oftentimes is, well, we relied on the employee benefit consultant, or, we're sort of taking their word for it. This paragraph here said, a prudent fiduciary is going to look at spread pricing. A prudent fiduciary is going to audit the PBM to look at spread pricing, to make sure the PBM is compliant with the contract. I think to really look at the generic drugs, the list, to look at the formulary design, which is some of the future slides, and also to ask the PBM, there's, Mark Cuban cost plus drug is one example out there where the drugs are much cheaper. Many of these big PBMs are excluding Mark Cuban cost plus drugs. Why? Because the PBM, it's way cheaper and the PBM is going to make less money. So is it prudent of a plan design employee to allow the PBM to exclude much cheaper drug alternatives? That's what this is kind of getting at here.
Yeah, what's interesting. Oh, go ahead, Pramod.
Yeah, I was going to ask a quick related question. You use the word loyalty, right? And I guess I have a question about what does loyalty mean? Because one of the things that we've seen in the market is often the companies who are buying PBM services may have business relationships with the PBM also. And so when you talk about things like when you have a business interest with the party that happens to be your healthcare supplier, your insurer, your hospital, et cetera, and it brings up loyalty, what does loyalty mean in that context? Who's got to be loyal to whom?
So I think this is another topic mode that is going to inspire a lot of discussion. And I'll give you an example. Let's say that, John, I sell computers and I sell $1 billion of computers to CVS Health. But I also owe a fiduciary duty to John's computer employees. I owe a duty to my shareholders too, to sell as many computers as I can. And there's some conflicting duties. If I am selling a lot of computers to CVS, and am I going to audit CVS? Am I going to say to them, hey, you owe me money on the rebate? I'm afraid if I upset them, maybe they'll stop buying computers from me. But so these big plans, they owe a duty to shareholders often to maximize value, but they also owe a higher duty, a fiduciary duty, which is the highest duty recognized under the law. They owe that duty to employees. So if you're going to compare the levels of duties, clearly the obligation to employees is the law recognizes a special one. But at the end of the day, how a court is going to have to answer that question, Pramod, is, okay, they're selling computers to this big PBM, but maybe the employees are better off having their jobs, having a higher healthcare cost, but the company is flourishing. That's the debate that's going to happen.
Yeah, that's fascinating. That's a great point, Pramod, as you think about it, especially getting back to these are some of the largest companies in America, right, that have business interests with a lot of folks, and it's the predominant model in the market. All right, so we think the lawsuit has merit, right? So I think the next question is, well, what's going to happen when this plays out in court? And frankly, does it even matter? And just kind of like thoughts on that. And John, but let's start with you, and then Pramod, interested in your kind of thoughts as well.
I think that what's going to happen is this is going to change the discourse entirely in the industry. It's going to, again, some of those paragraphs raise the question of, and Pramod, his last question was, what does it really mean, a fiduciary duty? It means that you're thinking only of the employees. That's what it means. Literally, you're thinking only in the best interest of the employees and no one else matters. So it's going to change the discussion. This lawsuit is going to change the idea of what does it mean to be prudent when you are managing a pharmacy benefit design, when you exercise the care, skill, prudence, and diligence expected of a plan design person within one of these big self-funded plans. This is going to change that discourse. How deeply are they looking at the PBM agreement? The definitions of generic and specialty, are they auditing? I think it's going to also change, Chris. Are you upholding your fiduciary duty if you just rely blindly on the outside consultant, the employee benefit consultant? And so if Chris, if you are a benefit design person at any big company, I don't want to say J&J, but a big company, and there's a deposition, and you're in charge, and the deposition of questions under oath, and the lawyer's asking you, what did you do? The lawyer's gonna have a list of prudence questions. Did you audit? Did you look at the formula design? Who did you talk to? How did you negotiate this contract? I think, MAC pricing. I think that's another thing this complaint goes into for generics. I think the impact of this complaint is going to change behavior in the industry for years to come.
So said another way, is it the burden just got a lot higher? So if you're in one of these traditional spread PBM contracts, and again, you relied on a consultant, or if you relied on a PBM to do it, that fiduciary responsibility is still yours. So it's almost like the burden of proof maybe follows to you, that you've done all these steps to make sure you're not overpaying. Is that a fair statement or way to look at it?
That's exactly it, Chris, because the duty is, what would a reasonably prudent person that is in your position managing the pharmacy design do? And if 3 years ago, no one really knew about these generic specialty things, they weren't really happening yet. People didn't really know about rebate aggregators, but now you know. And so the standard of care that people will be judged upon when they're making decisions about plan assets, these are employees' money. When you're making a decision on how to spend those dollars, you have to know more about pharmacy benefit design. The standard of care just went up.
Chris, related to your question, I think if you look at the 401k industry, if you look at what was the after effect of that, compliance suddenly started mattering, right? Because until then, there wasn't really a compliance question. It was just like, hey, we just did whatever. But when the laws and ERISA came into place, one of the biggest changes was now you had to fill out compliance documents that you had to sign, right? In the same way, we saw the same thing occurring with SOX, right, in the financial industries. And it really changed things, because when somebody has to personally sign or now attest to compliance, that's different than nobody asking the question, no one caring. So I am going to suspect that much like the changes we saw with both 401ks and with SOX in financial statements, this is going to cause people to pause, because now they're going to have to answer the compliance question.
Yeah. Well, and another point too that I wanted to bring up that has gotten a lot of attention, we talk about fiduciaries, and we say that word, and we've kind of talked about the plan or the plan sponsor, but then also in this lawsuit, specific individuals were named. Jonathan, can you just address that on kind of who is a fiduciary? Is it the organization? Is it individuals within the company? If it's individuals within the company, who are those folks and what duty then do they have personally, or what risk do they personally have?
Right. So Chris, you're asking because in this case, the plaintiff's lawyers, they actually sued the trustees of the plan. So to be clear, though, they didn't go sue the folks working in the benefit design department. And there was a reason why. The trustees clearly of a welfare benefit fund is what it's called. But the trustees of one of these big plans, they can be held personally responsible under ERISA, which is that federal law, if they've breached the duty. But just to be clear, I don't think people should come away from the presentation thinking I should freak out because I'm gonna get personally sued. That's not the point here. To get to that in a second, but so the fiduciary duty doesn't apply to the employees working for the plan. It applies to the trustees. So trustees can be held responsible, but of course, these trustees that work at big publicly traded companies, there's insurance, and they're going to be, they're not going to have to pay money out of pocket. No one's accusing them of individually stealing money. They're being accused of not meeting a standard of care. So, and again, I think if there's one takeaway, it's all I need to do is exercise reasonable judgment and prudence. Am I doing that? There's a very easy way to avoid these lawsuits and to protect companies and to protect against a personal lawsuit.
Can you just explain that? You mentioned trustees different than the people maybe working day to day in doing the benefit design and everything. Typically, when you have a trustee, what role is that? What level is it? You want to speak to that a little bit?
Yeah, I think you could consider the trustee of the plan is someone who's named by plan documents as the folks that are really in charge and supposed to be looking over the whole design and making sure that the fiduciary obligations are being delivered in one direction only to the employees and not to anyone else, not to third parties like PBMs and rebate aggregators and consultants. These
are C-suite folks like a CHRO or a CFO, something like that. Is that typically what you see?
Yes, they're people that are named within the plan welfare the welfare benefit fund documents. So no one on the call should be thinking, wait, am I a trustee? You would know if you're a trustee. You've been appointed under the plan documents as a trustee. It's not, a trustee is not someone who's like, oh, you're trustworthy, therefore you're a trustee. It's not like an obligor. You have an obligation to someone, so you're an obligor. It's not like that. The trustee is a specific title under ERISA. So people working in different benefit departments shouldn't be freaking out that they're going to get individually sued because they might be a trustee.
They likely will get more questions in from those trustees coming back, right? Which is, tell me about this plan, or potentially asking more questions that they weren't asking before.
Chris, I think that is a very likely outcome of this, is trustees are going to start really looking, saying, we need to understand pharmacy benefit design.
Yeah, got it. Really helps. So what is we've established, does it have merit? Will more come? But let's get into some specific things, really in the complaint that they called out. So when you look at some of these examples, seems to make a pretty good case. I guess it's a black and white example. So Jonathan, do you want to start with this one?
Sure. So what they're saying, the backdrop of this is we have a plan, and there's a pharmacy benefit management part of the plan, and we have a list of drugs called the formulary, and you decided to put this teriflunomide on the formulary, and you excluded Mark-Cuban cost plus drugs. Mark-Cuban cost plus drugs cash price for this is $28.40. And then J&J had, I guess would be the brand name drug, and it's $10,239.69. It's under the lawsuit. This is an allegation in a lawsuit. It says, no prudent fiduciary would agree to make its plan beneficiaries pay a price that's 300 times higher than the price at which the drug is, is widely available. And there's some good points here. Now, I'm sure there's some counterpoints. It's possible this employee is allergic to, you know, somehow the generic wasn't working and they needed the brand. But if the Mark Cuban if you are a trustee and you've allowed, in this case, Express Scripts, to exclude Mark Cuban cost plus drugs, the trustee should be calling up, like you just said, Chris, the benefit design person within the company said, I need to be armed with information when someone asks me, why did we exclude a cheaper alternative for our plan?
Well, it
Jonathan,
seems like in this one.
I was going to make
Pramod.
a quick point, which is that, you know, you brought up the point of maybe it's the brand. You're right. It could be the brand they're comparing to. And maybe, you know, J&J's system is different on how it actually reports. But the way that it's labeled, it's actually comparing the generic to the generic.
Okay.
And so, you know, often I think in plans, they don't necessarily use the generic, you know, doctors always generally use up generic names for things. But my guess is because this is a consumer site, that in this case, they may actually be comparing the generic to the generic. And that's even more egregious at that point because, you know, the arguments that you make, which are valid ones about different binder or something between the brand and the generic, some people could be allergic, are definitely true. But in this case, if it is a generic to generic, and that still could apply, but it's still a generic to generic. And I think, you know, one other additional point on this would be, one is that it's not just Mark Cuban cost plus drugs. Now, if you look at Mark Cuban cost plus drugs at $28.40 and compare that to Rite Aid, and you're like, you know, it's over 2x more. You're right, it is. So that is 200% more. But compared to what J&J allegedly is paying, which is $10,000 for that drug, what this is really saying is that, look, you could have almost gone anywhere. Right? You could have gone down the street to pretty much ShopRite or Walmart or Rite Aid, and I'm sure there's Costco and all these people on there. They would have had similar pricing, and it's all in that same ballpark. Because the other way I think about this is, look, if the cost of the drug had been $70 and cost plus was $28, who would have filed a lawsuit? Nobody. The reason they're filing the lawsuit isn't because it was 28 versus 77. They're filing a lawsuit because it was 28 or 77 versus 10,000. For the same thing, right?
And in terms of the benefit design, you know, the applied out of pocket $1,700 and is, you know, a $1,600 deductible. So this person was, as the lawsuit suggests, and maybe other parts of the complaint, this person was better off not even using their pharmacy benefit and just paying cash. And then the other point you raised about this being a generic to generic is, Pramod, would you agree that because this $10,000 drug is a generic, there's probably no rebate associated with it?
Yeah, and I think that's a really interesting point that you brought up, because if you look at the examples they've used in the complaint, right, none of the examples are rebated drugs. Every example they've used intentionally is a non-rebated drug, specialty generic. They're not rebated, right? And so they're intentionally using examples, smart on their part, to use examples that say, well, it's very hard for you to make an argument about there's some hidden rebate or something. There isn't. It's a generic drug. And so that key, you'll see that in a lot of the, you know, in every example. And then you also note, I think that, you know, one of the questions I'd think about, right, if I were on the other side, was that, could I claim that I didn't know? And, you know, it'd be hard to claim that everybody knows about GoodRx and Mark Cuban and all those things. I can't imagine there's a benefits person in America who could claim that I've actually never heard of these pricing differentials ever in my life, right? That'd be a hard claim to make.
It would not be prudent. It would not be reasonable. It would not be believed. It would be a breach to claim you didn't know.
So, Pramod, can you just expand on that a little bit? Because I think everyone in the call knows about rebates, and there's rebate retention on brand drugs and everything else. But this is a generic drug, right? So, like, why would the PBM not allow that generic drug to be filled through all these lower cost pharmacies? And why would they mandate it, you know, for you to pay so much more? Well, what's in it for them in that
sometimes, Chris, it's
situation?
kind of funny because you ask those questions and there are really complex reasons, right? And we're trying to find all these complex reasons to explain what makes no sense to us, right? Because as a third grader, if you look at this, you'd say, this doesn't make a lot of sense. And so when you're an adult looking at what a third grader would say, this makes no sense, we try to come up with these really complicated examples of, well, it must be this, it must be that. Well, in this case, there is no complicated explanation for this. It's actually really simple. And it goes back to what we talked about earlier, which is that one of the PBMs in their earnings report listed that this is one of their biggest sources of profit. So the simple answer to your question is, well, that's because I'll bet you money that this had to be purchased because it's a specialty generic. It had to be purchased through the PBM's own specialty pharmacy. And so the answer to that, it's kind of simple. It's that they would be losing thousands and thousands of dollars because of the markup that they are able to command. So in this case, at least, it is a simple case of just egregious markups and just what we would call price gouging. If somebody in the rest of America were to charge these types of multiples on a product compared to the market, we would be in court accusing them of price gouging, right? No one would be saying this is okay to charge $10,000 for a $30 drug, right?
Yeah, and Jonathan, the point you brought up about cost plus and then Pramod, you adding on that this wasn't just cost plus, there were other pharmacies, but I think a quick takeaway for any plan sponsor on this call, one of the great things about Mark Cuban is the price is transparent and it's the same for everybody. It doesn't change by location or where you live or by the day necessarily. So you can look at your claim detail, look at the drugs that are listed in this suit, see what you actually paid through your PBM contract, compare it to the publicly available cash price, right? And if you see that same sort of difference, now that kind of raises your next level of diligence. And that's kind of where I wanted to go next. So, Jonathan, when you see examples like this, right, they jump out. So what will the response be from J&J? How will they say, well, this was okay in some way? What's going to be their counterpoint to that?
I think they're going to have to say we hired the best PBM. And they're going to show some literature they got about, why the PBM selected this particular formulary. They better have a good explanation for why this drug is so special compared to the other generics in the class. They're going to say we also hired literally the best consultant, the employee benefits consultant. They're going to say maybe not with this example, but they're going to have to, as Pramod said, the plaintiff's lawyers selected intelligently from the formulary, because if I am Johnson, they're going to want to say that comparison of $10,000 versus $28 is not accurate because we received the benefit of rebates on these other drugs, on this particular drug. So in other words, it cost $10,000, but we got a $9,000 rebate, at least something. But they're going to have to show that that these were cherry picked, that overall they had a very intelligent benefit design. They're going to have to show that they received, maybe we overpaid on some drugs, but when you look at the totality of drugs, we received, based on the rebates we received, we got amazing rebates. They're going to have to show that we got Express Scripts to when we're using their mail order pharmacy or using their specialty pharmacy, we got great rates. They have super low rates. I mean, they're going to have to come up with their own statistical studies and designs. And they're going to have to show that they honor the fiduciary duty and that they knew how much Express Scripts made and how much Aon made. Because under the Consolidated Appropriations Act, they're supposed to know and learn how much those vendors made, because under those acts, a plan is only permitted to pay a vendor reasonable compensation. So 10 grand for something that's $28, is that reasonable? If it's not reasonable, it's a breach. But obviously you have to look at the plan in its totality as opposed to one example.
So, related to that, I guess my question would be, how would it be possible at the end of the day, it's saying, hey, it's on you. If you're going to make an argument of cross subsidization, right, such that rebates or I had lower prices for Humira, for example, and that's why I had to pay $10,000 for, teriflunomide, for example. But how would you be able to make those claims if you don't actually have line level pricing on what those items are? So I'd argue that, number one, we rarely see employers, and I'd be shocked if J&J has line level detail on, okay, great, every specialty drug out there, the rebated ones, the non-rebated ones, et cetera, I've got the net price on it. If you didn't have that information, how would you be able to compare and argue that this was a cross subsidy that was beneficial versus a cross subsidy that you actually paid more for?
Well, and I think it's a different question too, Pramod. So one, it's, hey, rebate and other contracts, somehow you made out better as the plan, right? We gave you these rebates back, that lowered your costs and premiums. But then it kind of gets into the rebate game in general. which we walk through on the next slide, which is we'll explain that cross subsidy, right? And how some bigger rebate somehow leads to a better use of my plan assets as a fiduciary. Do you want to talk about this?
Yeah, I mean, so
Pramod?
what this slide, and I'll go through in a little bit of detail. It actually suggests that mathematically it would be impossible for that situation that we just talked about, the cross subsidies costing less with the rebates. And here's why, right? So just a couple of data, facts for you. Rebates are not butter knife. Rebates actually depend on the actual disease and the conditions themselves. So as of this past year, when adalimumab went to its biosimilars, rebates are now concentrated to about 90% of rebates are in inflammation. So what does that mean? That means that if one of your members is on an oncology drug like Keytruda, there's no rebate on it. So someone making an argument that, hey, this somehow subsidized, the price of Keytruda, it's like not possible, right? That's not where the subsidy is coming from. That's not where your rebate's coming from. And if you go down that list and you look at, well, what's the biggest contribution, for example, in inflammation, which is 90% of rebates, that comes from Humira, right? And so what a really simple experiment that you could do is go back and ask, well, if that were true, then what would the price of Humira be? Right? And how would I compare those things? Because that's what I have left over, the inflammation drugs, because that's where my rebates are coming from, right? It's public knowledge. This is public information about rebates, et cetera. And so if you're making that cross subsidy argument, for example, where you're going to have trouble also is that this gives you sort of the breakdown of, if you took Humira with the best rebates on the market. So these rebates are what we hear from the industry that would apply to the largest companies in the US, which are probably the ones that are named in these kinds of lawsuits and will be in the future because they have the best contracts. And you go back and ask, well, what's their net cost? Right now, their net cost is around 30 to 35 grandish for Humira, okay? And here's a problem with that, which is that if you were to compare it to the generic or the biosimilar, right, which now even the FDA is saying we can remove, nonsensical requirements like interchangeability and these statuses that don't actually mean anything. If you go back and look at the comparison there, Mark Cuban Cost Plus, they sell that cash and carry for $8,400 a year, right? Anybody can go and buy that. It's public knowledge. There's no rebate required. So with the best rebates, if you're going to argue that there's a cross subsidy, you're going to have to explain to everybody, but how much are you paying for Humira, right? For example, and all of these other drugs. And this simple example just shows that you're going to fail miserably in the math, even with the best rebates when you add them up, because the cost in the open market for a competitive product, in this case, biosimilar, is about a third of what Humira costs after rebate.
Pramod, have you seen, Chris, if you don't mind if I ask a question, because I've seen scenarios where PBMs say, fine, if you want to segregate out specialty drugs, if you want to hire a different pharmacy for specialty drugs, you don't want to hire our wholly owned specialty pharmacy, or if you want to control formulary, that's fine, but you're not getting these other rebates. Do you see that game being played? In other words, we're making money on Humira, but if you want to include the the Coherus one with Cuban, that's fine, but we're going to reprice everything else in your book of business.
Actually, we hear that because, again, we don't see it directly because we're not an employer, but we hear that from employers and their consultants like pretty much every day of the week. In our own experience, we've got customers that are paying 7-figure a year penalties just for carving out specialty, right, from your PBM. And so if you go back and ask, well, why are they charging a 7-figure penalty? Well, because they were making so much money on this and nobody really needed. I mean, if you ask, why would somebody hire us or an alternative, right? In this case, because there are alternatives to us also, right, in this space, it would be because you're going to pay less, right? And they end up paying less, and then they get charged penalties on the other side to recover the cost of what they were making before.
Well, and I think that's a great topic because this is looking at rebates, and this gets into, Jonathan, where you kind of talked about this is going to change maybe the entire industry and the way we evaluate things. So typically, PBMs are evaluated traditional PBMs like the big three by the rebate value that they guarantee back to the employer. And so I think the key here is if you have a contract that is based on rebate guarantees, that PBM cannot fill you summary on the right because they're not going to meet the rebate guarantee. The only way they meet their rebate guarantee is if they fill the drug on the left, which gets into this broader thing, which is who is running the RFPs? Who are the employers reaching out to for help to say, am I overspending? Am I not overspending? And it's interesting in the complaint, if you go to the next slide, please, that really, it calls out as well the specific consultant in this and some other financial interest or potential business dealings on this. So, Pramod, do you want to speak to this?
Yeah, I mean, obviously, this is just we're just copying what's in the complaint, and they're pointing out who their consultant was in this case. I mean, you could potentially fill in other names here, but I mean, the thing to walk away with isn't who the consultant is; it's what they did, right? That's the important question that we should be concerned about. And in this, what they're arguing is that often consultants have financial interests that steer their customers in certain ways. And if you go back and you're trying to convince yourself that, well, I'm not really sure that that's a thing, right? The Consolidated Appropriations Act largely came out of the fact that people who are in the middle often have financial interests that they don't disclose that are in conflict with what you're trying to achieve as a fiduciary. That's where it came from. And in this case, we often see where some of the consultants, for example, for example, look at some of the consultants and you see that they have their own coalitions in which they're paid millions of dollars a year in fees by one of the big three, for example, for running a coalition. And so when you step back and ask the question of, wow, it seems like everybody's pockets are getting padded. Let me just bring up an example, right? It turns out that a lot of specialty pharmacies didn't want to carry YUSIMRY. And you're like, why? Because most pharmacies make a percentage of the cost of the drug, right? As from a revenue perspective. So do you want a low-cost drug or you want a high-cost drug? Well, I want a high-cost drug because I make more money. And you work your way down the chain and ask, hey, who's got an incentive to actually sell things for less in this country? And it turns out that unless you're Mark Cuban and you're not from the healthcare industry and you're like, screw this, I'm going to fix this, everybody else seems to be looking at how do I make more money by jacking up the prices of things. Whereas, so as you start looking at this, you start realizing, wow, everybody's getting a piece of every dollar that goes through. So it's this self-reinforcing industry of participants. And the consultants and other folks that you expect that are completely neutral, that you are paying, right, a service fee for doing these analyses, then at the end of the day, you find out, wow, they've also got conflicts. They also do business with some of these PBMs and other, for example, you'll find that some of the consulting firms actually consult for the PBMs also. So the PBMs are their customers. And so now we're running into what you brought up earlier, Jonathan, of hey, these guys pay me a lot of money. These guys pay me a little money, on a per employer basis. Who am I going to optimize for? I'm going to optimize for the people who pay me a lot of money, right?
Well, and an interesting point about this too, and I have no knowledge of the specifics of Aon's relationship with J&J, but it's well known that Aon and some of the other consulting firms run their own coalitions, which is basically their reseller agreements, right? I'm reselling now a PBM contract. I'm guessing based on Johnson & Johnson's size, they are not part of that coalition. Those tend to be more middle market focused. So in this case, it's an interesting argument because I doubt that Johnson & Johnson was part of that coalition. So they were separate, right, negotiating its own contract. Yet this lawsuit is pointing out they're still, because of other relationships or other reseller agreements or other revenue sources, they're still saying that Aon could have been conflicted this and not been able to provide independent guidance to the plan sponsor, which is an interesting kind of extension of that. So I'm watching time. I want to go through just a couple other questions. I mean, I think the thing that was sitting with me when I read this lawsuit as well is you kind of read through, and I think everybody in the call has known the challenges with the spread PBMs. Congress is all over it. They're talking about it all the time. So, I mean, given the lawsuit, what's pointed out, I mean, if you are with a big three PBM, what is your burden now, right, to prove that you've met your fiduciary responsibility, or is it even possible? Jonathan, do you have any thoughts on that?
Yeah. Yes, I do. So I think, if you're using one of the big three PBMs, you should be prepared to discuss the following. I didn't blindly rely on an employee benefit consultant like Aon or others. I very carefully tracked how much the employee benefit consultant was making directly or indirectly through coalitions. I wrote them a letter. I said, under the CAA, I can only pay you, broker, if I pay you reasonable compensation and if you disclose it to me. If it's not, ERISA says that is a prohibited transaction under ERISA. So they have to be able to answer that question. I think if you are using a big three PBM, you also have to be able to say under oath, I did use the BPM. I'm aware that there's some public discourse about ways that there's misaligned incentives, but I audited the rebates to make sure I was getting the full rebate. I audited spread pricing. I had an intelligent look at my formulary. We talked about, generics on the specialty, MAC pricing. I really carefully looked at the formula I audited. They've got to be prepared to say, I've done those things. If you're using a big three PBM, that's not pass-through pricing.
Hey, Chris, and if I could add a caveat to that, I would also argue, why? Why would somebody choose something that's more complicated and creates more work and attestations where you're lying awake at night thinking, hey, is somebody going to sue me because I wasn't quite sure about the answer to this question, versus saying, hey, this is healthcare. I'm a purchaser. I'm buying this stuff. I should have a right to get every single price of everything that I'm paying for. There should be no ambiguity about it. I should not have to extrapolate anything as a buyer. And if there are solutions like that on the market, my question is, why would anybody even buy such a model that says you don't have access to all of your information?
Yeah, and so I think point being, in the complaint, they actually list other models, and they list, transparent models and some of these other things, with the wording being, you should have explored these, or, Pramod, to your point, there is an option. You don't have to do it this way.
And of course, we're one of those options that was listed in the complaint, right, from public information. And what was interesting about it is that when people saw our name, they probably thought the lawyers had reached out to us or talked to them. We had no idea about this lawsuit. No one's ever reached out to us. And they pulled publicly available information that anybody could have pulled up.
And Pramod, if I could just add super quickly, you mentioned access to information. It is the law under ERISA and CAA. All the plans are entitled to information. We represent plans. We sue PBMs. We have multiple lawsuits or arbitrations right now. The first thing we do is we say, we're doing audit, we want the data. All the big PBMs respond. They have big firm lawyers, and they say, you're not entitled to the data. You're not entitled to your own data. And they literally do not give access to data. So if you're a plan and you owe a duty of prudence and you don't have access to data, in your words, Pramod, that's a problem.
Yeah, and let's sum this up. It's been a great discussion. I want to leave a few minutes for questions here. So just real quickly for folks, Jonathan, just building on what you just said. So how do you meet your fiduciary obligation? Step one, reach out to your PBM or health plan and immediately get that item level pricing detail, right? This lawsuit pointed out, you can't, to use Pramod's term, look at a butter knife and say, we did better in RFP. You actually have to look at what you spent and compare that to the costs that are available, in the open market. Mark Cuban is brought up in here, other low-cost pharmacies. I mean, there's got to be something in here too, where you ask that PBM or health plan, say, immediately, I want to be able to fill drugs through Mark Cuban or any pharmacy. If these drugs are less expensive, I want to be able to fill them there and not overpay. And by the way, that includes Yosemite, which is available to a few other pharmacies as well. It's not just Mark Cuban. It's out there, yet they've been locked out of the market largely because they're not paying a rebate, because that kind of goes against the system. Hire a non-conflicted pharmacy consultant to do the analysis. Again, this line item, make sure you're buying the right drug. So it's not just comparing drug A to drug A in the cost. If it's drug A is a heavily rebated brand drug and drug B is a low-cost generic without a rebate, it's still available. You have to look at that and see you're overpaying if you're just trying to get the rebate. And again, explore alternatives. They listed, a lot of options in that lawsuit, transparent options, to the points brought up, which is if you don't want to have this burden, you can also just kind of release that burden and be with somebody who's going to provide the data, who's going to provide the information, and you're not going to run into these same issues. So, Jonathan, Pramod, thank you very much. To everybody on the call, I'm going to go through the questions now. If you have some, please submit them in the Q&A section. That's where I'm going to be looking. And even though we only have a few minutes left, we will respond to all participants and answer every question in the Q&A, even if we just even if we aren't able to get through them all today. So, so one question came up: when PBMs reimburse their own specialty mail pharmacies higher than non-owned specialty mail pharmacies, are those pharmacies reimbursed lower considering claims against plans? So I think it's like, what is really the incentive, and will independent pharmacies, are they losers, in this situation, even when they're competing or when they're part of a covered plan or in the network?
Yes, almost always, especially in this self-funded plan context. Self-funded meaning it's not fully insured. And so, when ERISA applies, the independents get often entirely excluded, or when they are included, they are often priced well below. And then there are many state laws that are popping up that have this like parity. You can't pay your wholly owned pharmacy more than independent pharmacies. Sometimes those state laws are they don't apply. They're preempted by ERISA, and so sometimes, and it's another thing that plans need to understand, that technically the PBM under state law could pay themselves more than independent pharmacies, and so why give the PBM exclusivity for specialty drugs, for example? It really doesn't make sense.
Chris, related to that, I've noticed a really interesting phenomenon over the last couple of weeks since this lawsuit came out. I have had more conversations with providers of healthcare who are concerned about this than I've had conversations with employers who are concerned about this. And if you step back and ask, well, why is that? Well, it's the people who are making this money who are the most concerned. So, for example, if you're a hospital system and you're overcharging by 2x everybody else, you're concerned because this lawsuit also exposes your revenue model as a result of this, right? Because if you step back, what are we really saying? We're really saying that, look, employers, you're required to make sure that the people who are your suppliers are charging you fairly. But who's that going to affect? It's not going to affect the employers, right? Because the employers have been paying claims forever. So to them, it's just like they're paying claims. It doesn't make any difference to them other than potentially they could pay less. But somebody in the system is actually being affected because their revenues are getting trashed. Who are those people? It's the pharmacies, the PBMs, the healthcare system, et cetera. And they seem to be way more worried about this than even employers are at this point.
Yeah, interesting. A question came up, which is a good one. An employer said, hey, we're in the middle of evaluating our PBM right now. We've looked at pass-through pharmacy arrangements, and the guarantees coming back are less than the big three. They believe that their consultant is relatively independent. So they're kind of stuck in a position where if I've gotten this analysis back, what am I supposed to do? Pramod, do you want to talk about the analysis process and the RFP process itself and the questions that it's asking?
Yeah, that's a great point. I mean, I think if you go back to that Yosemite versus Humira slide, right? The reason we ended up with that slide is because when someone's evaluating this question, they're not asking the question of, I just want to know how much all this stuff costs. I don't really care about how you make sausage and what the rebates are and all of these other things. But instead of asking how much it costs, today, everybody in the system benefits because they're not asking that question. And they ask the question of, hey, tell me what my rebate guarantee is, or tell me what my discount guarantee is. What does your discount guarantee have to do with the $20 drug at Mark Cuban compared to your $10,000 drug? The reason why those drugs are that way and allows you to play that game is because somebody asked the wrong question to begin with. about a discount guarantee. And many of you, if you haven't seen this, Anthony Chiacha and 3Axis Advisors last year did this exhaustive study of the big three PBMs and how each one of them moves definitions so they can meet better discount guarantees and these metrics that consultants are looking for. So the problem out of the gate is that they need to start asking and saying, I don't really care about any of this stuff. I just want to know how much all of this is going to cost. And it starts with asking that rather than discount guarantees or rebates. Those are the wrong questions to be asking.
Yeah, I just want to underscore that. If your PBM evaluation is looking at discount guarantees and rebate guarantees as the basis by which you're going to make a decision, it's the wrong
You'll end up
process.
with this. You'll end up with this right here. This slide
is what you end up with. So one question too, Jonathan, I'm going to point this to you. So this cross subsidy, right? And you see these examples where people are overpaying in their plan, and somebody asks, I mean, isn't that discriminatory? You know, what about that person who the out-of-pocket, I think you showed, paid $1,700 out of their pocket for that drug? They don't care if somehow the contract is better on some other drug. I mean, isn't it discriminatory to knowingly overpay for some drugs when members have to pay that out of their pocket is the question.
I think it's a different analysis. The ERISA is a different analysis. We really look at the plan design as a whole. Yeah. But there are instances where a certain class, like HIV drugs, there was a case in California where that was successful by an HIV coalition that said, Caremark, CVS Caremark, you cannot exclude these drugs and make them as a class of drugs mandatory mail order. Because as a class, you're discriminating, you're treating us differently. That's a specific example of discrimination within the context of formulary design. When we think of discrimination, we think of sort of a federal law that's protecting a class. And HIV and cancer actually are two different classes of drugs that have federal protection. But I don't think this example is one of discrimination. I think a plan design person doesn't have to, design the plan for one particular person, but they also can't harm a particular class of protected people for sure. But I think it's the overall prudence in design doesn't require that you look at one instance. It requires looking at all of them.
Got it.
So Jonathan, you brought up cancer. Like a lot of those drugs that are listed, like imatinib at Mark Cuban, the example, they're actually oncology drugs.
Yes.
And so in that case, because there are federal protections for oncology, could the class of all of those people, because those are very common drugs too, right, in the oncology space. They aren't like there's one person at J&J on imatinib. Yeah. If they've got, J&J's probably got a lot of people on imatinib, right, who are all oncology patients. Do they have any protections in this case because it's an oncology drug that they're being forced to overpay for versus just paying cash outside?
It is possible. It's possible. The complaint certainly doesn't raise that. And I don't think that would be a different kind of case, but the federal government does recognize anti-neoplastics, cancer drugs, as a type of drug that has a certain elevated protection, HIV, cancer drugs, and four others. I can't remember which ones they are right now, but there probably is some argument there, maybe outside the context of ERISA, or maybe it would be. No one's ever made that argument that I've seen in there. This is a first of its kind case. So we'll see how it develops.
So Jonathan, I'm going to ask you to answer this really quickly. So what somebody asked, knowing all the different ways PBMs can make money, traditional PBMs, a self-funded plan, how can they independently audit all of those different revenue sources and look at it just real quick?
So very quickly, I would focus, and what we focus in our plan sponsor group practice is rebates. I focus on making sure that the rebates that a manufacturer pays to the PBM's rebate aggregator, and then the rebate aggregator pays to the PBM, and the PBM pays to the plan. I make sure that the retained rebate is not a breach of contract, that it's exactly what the contract required. And I think that every plan is going to find retained rebates in breach of the contract. I would also look at the spread pricing. That is when the PBM is charging the plan $1 and then reimbursing 80 cents, and the contract says no spread, and they've been hiding it. That's why you need access to your data.
Yeah, excellent. Well, thank you, everybody. We're at time. Really appreciate everybody, the engagement. Jonathan, Pramod, thank you very much. As promised, we're going to send out a recording of this webinar Also, a more detailed white paper that's going to go into more details on a lot of these items we talked about. And again, we'll address all the questions we didn't get to during this session today. So thank you again, everybody, and enjoy the rest of your day.